Alright, so let's look at some of the case laws that clarified on the provisions of sedition. Now, if you look at some of the pre-constitutional law case laws, you can see the first one is Emperor versus M.K. Gandhi. Uh, our Mahatma Gandhi was once an editor of a newspaper called Young India, where there was an article which talked about how the British rule was being restrictive and is being imposing and against the interest of the Indian society. So, because of certain articles of that such kind were posted in the paper to which Gandhi was the editor, a charge of section 124A was made against him. Gandhi did Interestingly, Gandhi, instead of arguing against the provision or against his charges, he accepted guilty and made the statement before the court that he agrees and he pleads guilty to the action for the reason that he agrees to what has been given in the newspaper. Gandhi was sentenced to 6 years imprisonment for acting or exciting public against the British India government, though he was released after 1 year under certain circumstances. Similarly, you would also observe that Bal Gangadhar Tilak, one of our famous freedom fighter, was also charged under section 124A, and there you will see how the courts have approached one section 124A. So Bal Gangadhar Tilak was charged for for certain speeches that he had made during the British India period. And some of the speeches targeted at how the civil service exams and how the civil service were conducted and how the British government was unfair in its means and how the Indians were not made a part. This was evaluated and the court looked at it to say cannot be treated as a case of sedition directly, and he was acquitted on the condition that he was monitored about his behavior over the period of time. So you can see that how sedition laws or those that was used primarily for the Britishers to control the Indians and how the Indians do not speak against the government or British government in India. Post Constitution 1950, there are multiple cases that was brought about where the courts have been very cautious in applying and to clarify that mere commenting or criticizing the government cannot be brought within the purview of sedition, and it is necessary that the statement made is capable of affecting the public order by exciting or pushing the people to act against the government. There must be disloyalty injected into the people that they react. So, the moment I have made a criticism against the lockdown policies, I'm all right, I'm exercising my freedom of speech and expression. But the moment I instigate the public to come on road and there's a possibility it is likely to be affected, in that case, in that case alone, sedition laws can be attracted. The constitutional validity of it was challenged in three main cases: Tara Singh Gopi Chand versus State of Punjab, Kedarnath versus State of Punjab, and recently in Common Cause versus Union of India. But interestingly, in all these cases, the constitutional validity has been upheld. The prime reason for challenging the constitutional validity was whether the provision of section 124A and section 505 violate article 191A of the constitution. Every citizen has the freedom of speech and expression, but what is relevant to note here is that it is subjected to 19 clause 2, where it there are certain 8 restrictions provided under, and one of the restriction is for the purpose of maintaining public order, freedom of speech and expression can be curtailed. The justification of still retaining section 124A in the Indian Penal Code is to retain public order. The moment someone comes forward to instigate the public against the government, then if it is likely to interrupt the public order, then it is a fact where it is likely to be punished under the law. Similarly, we have some cases as an example where first one Balwant Singh versus State of Punjab. There were slogans raised against Indira Gandhi when she was assassinated. The government officials took that as an offense, and Balwant Singh was charged under Section 124A. But the court held that the slogan that Balwant Singh raised did not instigate the public to act against Indira Gandhi, and it was treated as a casual slogan. Similarly, in the case of Bital Ahmad Khan versus State of AP, where a Kashmir youth made certain statements about how Indians were creating atrocities in the Kashmir region. But this again was not treated as sedition, as the student was expressing his opinion about the acts of Indians at that point of time. So it was not treated as a case of sedition. The next two is a very important case, which is, as all of you know, where cartoonists were the case of visual representation. I will take it from here in the next slide.